Good afternoon, ladies and gentlemen. We'll call the meeting to order then. Welcome to this would be the second committee meeting of this session of the Standing Committee on Access to Information, Privacy and Ethics. We're very pleased today to welcome the Office of the Information Commissioner of Canada, the Information Commissioner herself, Suzanne Legault. Welcome, Madame Legault. And she's brought with her Leila Michaud, the Director General Corporate Services Branch. And technically, we're together today to examine Supplementary Estimates B, and by extension, the general operating budget of the Office of the Information Commissioner. I understand you would have opening remarks, Madame Legault?
Yes, I do, Mr. President.
Well, then the floor is yours. Thank you.
Well, first of all, Mr. President, I must say that I am actually very happy to see that all of you are here and safe and sound. So,
thank you for
with that, I think we can start with our regular business. Bon après-midi à tous. Je vous remercie.
Good afternoon. Thank you for asking me to appear today. I'm here with Leila Michaud, my Chief Financial Officer and Director General of Corporate Services. Mr. Chair, I would like to tell you briefly about the work my office has been doing to support transparency and accountability during my term as Information Commissioner. I am doubtful, however, that I can sustain this important contribution to Canadian democracy given the volume of work and the financial situation the office is currently facing. As you know, the Access to Information Act establishes the Office of the Information Commissioner of Canada as the first level of independent review of government decisions about releasing information under the Act. Requesters who are not satisfied with how institutions handled their access request have the right to complain to my office. In turn, I have the legal obligation to investigate all complaints that fall under the Act. There is no discretion. We have to look into each complaint. Because of the work of my office, Canadians often receive more information than institutions were originally willing to release. I also help requesters get information more quickly. After the Lac Mégantic tragedy, for example, I was able to secure much earlier releases of information than Transport Canada had originally proposed.
I looked at all my investigative and business processes to identify efficiencies, and I significantly improved how my team handles complaints. As a result, we have closed, since I have been Commissioner, more than 10,000 complaints. This is the volume of work that rests with the OIC. Most of these complaints were resolved without the need to resort to the federal court, which is the second level of review under the Act. For the remaining unresolved cases, my legal team has litigated these matters before the courts with the consent of complainants. Over the years, I've also made recommendations to the President of the Treasury Board on various ways to advance accountability and transparency. I'm very pleased that most of these recommendations over the years have been implemented by the government. Through the last 4 years, I also found better ways to carry out crucial financial and governance functions. I did internal reallocations to provide maximum support to investigations. I have been able to achieve these accomplishments as my budget was decreasing. The reality now is that I have 11% less money than I did when I started to do the work. Then last fiscal year, we faced a 30% increase in the number of complaints, which has brought the organization to a crisis point. Despite closing 10% more files again last year than in the previous year, the inventory of complaints grew by 16%. That was the first such increase since I have been Commissioner or Interim Commissioner for the last 5 years. So in addition to having an investigative team stretched to the limit, I have no financial flexibility to augment my investigative capacity or to set aside for contingencies. My budget is so tight that last year I lapsed $37,000 at the end of the year. I therefore have no money to respond to unforeseen circumstances. For instance, if one of the server breaks down at the OIC, I will not be able to replace it. There is not enough money. This is the situation that we are facing now, and obviously I will have to take action. Les choses ne vont pas aller en s'améliorant, Monsieur le Président.
The situation will simply get worse, Mr. Chair, since both the number of complaints and the financial pressures will continue to grow. Unless my budget is increased, I have only one option going into this new financial year to keep within my appropriations, and that will be to cut the program. This is not a decision that I take lightly. My independent oversight role is crucial to the access to information system, which is itself the foundation of transparency and accountability. The government has identified these as priorities. The work that I and my office do is crucial to being able to meet them.
Between when I receive files in the office and when they can be assigned to investigators is increasing. The resulting delays are already jeopardizing the right of access. Requesters will have to wait even longer to get information. This, in turn, will delay their rights to pursue the matter through the federal court if they wish to do so, since they must wait until the investigation of the OIC is completed before exercising their right to go to court. For instance, Mr. President, at this time, the delay between receiving a file and assigning a file varies between 6 and 7 months. So this will increase even more. Such developments are the last thing I want to see for Canadians that have a right to timely access to government information. I have raised the red flag about this financial situation at every available opportunity. I have also pursued every option available to me to preserve my budget and ensure the integrity of the program. This includes making requests for funding through the 2014 and most recently the 2015 budget process, so far without success. In conclusion, let me say that I believe our actions at the OIC during my time as Commissioner clearly demonstrate what I have always believed, that effective management of public fund is of paramount importance. I have told committee members in the past that I would have very difficult decisions to make to keep within appropriations, deliver on my mandate, and maintain excellence in governance. I have certainly had to make these decisions. As I said in my last departmental performance report tabled in Parliament recently, without additional funding, I will no longer be able to carry out my mandate responsibly and ensure full respect of Canadians' right of access to information. En l'absence de ressources supplémentaires,
without further resources, I will, as a responsible steward of public funds, need to make cuts into the program to ensure my office continues to operate with the appropriations granted. Rest assured, I will back away from the fiscal cliff rather than going over the edge. But as I do, Canadians' quasi-constitutional right of access will be increasingly denied. With that, Mr. Chair, I would be pleased to answer any questions you may have.
Thank you very much, Madame Legault, for a very sobering presentation. We'll go immediately to questions then. I believe it's 7-minute rounds, and beginning for the NDP, the official opposition, Charmaine Borg.
Oui, merci beaucoup. J'aimerais vous remercier d'avoir pris le temps de...
Thank you very much, and thank you for taking the time to testify here today. Obviously, you've informed us of a situation that I think is troubling. Your role as Commissioner is very important. It is to ensure that Canadians have their rights respected when it comes to access to information. You've indicated that there's been a 30% increase of complaints, but that your budget has gone down by 9% since 2009. I believe that you have 11% less money since the beginning of your mandate, but as you indicated that, you've indicated that pressures increase. Obviously, this is a serious problem for you. You mentioned that you may have to make cuts into the program. What do we do with this? What are the consequences for you? Is Canadians' right to access to information going to be at risk because of this? Yes, exactly so. As I was saying in my presentation, it's my problem as the administrator. However, it's Canadians' rights that are affected. It's not my work. It's the rights of Canadians that are affected. As the administrator, given the financial situation, I've made cuts everywhere in the office. I've already made reallocations of funds. I've already done what I can with investigations. We're constantly working to improve when it comes to efficiency. But the improvements I can now make when it comes to investigations are improvements that I would qualify as marginal. They are not improvements that would allow us to treat the 2,200 complaints that we currently have in inventory and to deal with the additional complaints we get on a regular basis. I've done everything I can as the general administrator, but now I need to put myself back in the hands of the government and parliamentarians. You are all my bosses, essentially. And I need to tell you that despite everything I can now do, the quantity, the volume of work is such that we can no longer meet Canadians' demand. Thank you. You've said that we're your bosses, but our bosses are all Canadians. And I would imagine that we need to make sure that their right to information is respected and that you need a budget to meet that need because the number of complaints is going up. If I understand correctly, you had $37,000 left for the rest of the financial year, which is 0.2% of your budget. Have you consulted with the government about this need to rectify the financial situation, if you will? Have you made an official request to the Treasury Board? Yes, if you look at tab 2 of the documents that I distributed, it is the timeline of the events when it came to budget requests with the government over the last few years. If you will recall, officers of Parliament a few years ago had to report their finances to the consultative committee. In 2010, we made an emergency funding request to deal with a specific case. Afterwards, there were restrictive budget measures that were implemented. When we asked officers of Parliament to submit recommendations when it came to cuts as part of the Deficit Reduction Action Plan, we indicated to Minister Nicholson that we could not absorb any further cuts. But our funding was still cut by 5%, which in a real amount represents 6% of our budget. We are the only officers of Parliament, as far as I know, who had cuts that went beyond what we suggested to our minister. Last year, we were required to leave our office, and when we left those offices, the government asked us to fund our move. At that time, we made a presentation to the Treasury Board in which we explained our financial situation and said that we could not actually pay for the move of the Commissioner's office. It was suggested that we fund the move with a loan amortized over a 15-year period, which we would have to pay back, which leads us to another 2% cut. Over the last 2 years, 2014, 2015, we made submissions through the Minister of Justice, who is the minister responsible for our portfolio, to be part of the federal, to be included in the federal budget and make a submission to the Treasury Board. My colleague had conversations with the Treasury Board Secretariat, has been having conversations for some time in order to determine through which mechanism we can request funds as a government agency. I believe that Ms. Michaud had conversations over email this week because we are ready to make a submission to the Treasury Board, but we're told to go through the Minister of Justice, to go through the budget implementation exercise. That's what we're doing. If the government tells us that they're going to consider a submission to the Treasury Board, obviously we will submit it. It's ready to be tabled, in fact. I have 30 seconds left. I wanted to ask you a question about the Open Government Action Plan and the fact that we need to harmonize with the Access to Information Act. I don't have a lot of time to ask you the question, but could you talk to us about the lack of modernization brought to this act? As I publicly said in 2 letters that I sent to the President of the Treasury Board, I am very much in favor of the Open Government Initiative. I was one of its main advocates at the beginning. Therefore, I'm very pleased to see that the government is launching this initiative. In my opinion, the essential point, the fundamental pillar of this particular exercise is modernizing the Access to Information Act.
Much. Then first speaker for the Conservatives, Mr. Aaron O'Toole. Welcome to the committee, Mr. O'Toole.
Thank you, Mr. Chair, and thank you very much, Madame Legault and Madame Michaud, for appearing today. I have the good fortune to be substituting today and to have an Officer of Parliament on a subject I've often had some questions about myself from my past life as a lawyer, so this will be a great opportunity for me. And I would like to thank you. It's clear you've been very diligent with the budget, very close to estimates, not lapsing much, and closing more, 10% more. That's impressive, and thank you for that. Your concern about the volume of work leads to a number of questions to help me get an understanding. So the 30% jump that you're seeing in cases, those are unresolved access requests from the 27 institutions of government. Is that a fair way of describing it?
They are complaints. So there are about 250 institutions that are covered by the Act. Last year, or not last year, the year before, which is the last year for which we have statistics, the government received 55,000 or so requests across the system. That was about 27% increase from the previous year. This was completely unprecedented across the system, so it's not just my office, it was really across the system. And I can say as well, sir, that it was not related to any issue, any specific departments, no trends that we could see. Same thing in our complaints. Usually if there's a big jump, there's a topic, there's an institution, there's something that happens, there's a big surge. That year, nothing like that, no trends whatsoever. It was across the board, huge increase, and the main increase came from members of the public. So the only thing I can surmise from what I see in the data is that there is clearly a heightened awareness in the members of the public about their right of access. I can't see any other trends.
So the 30% jump you're increasing is consistent with general increases for ATI requests across government?
Yes.
And who, by and large, are the requesters? Certainly when I was a lawyer, ATI requests could be part of regulatory preparation for large companies. It could be part of a litigation process. Certainly the media are well known for some of their ATI requests that find their way into newspaper articles. Is there a breakdown on how many are commercial in origin versus a citizen inquiry?
There is. Treasury Board statistics, I think I have them here. As I said, that year where we had the big jump, they were truly, the majority was from the public. I have them here, I think. Est-ce que tu les as? There it is. So, yeah, the public was first, and then second was business. So out of the 55,000 requests, you had that year 22,000 or so that were from the members of the public, and 21,000 for private sector business. That's a very broad category, sir. It's very difficult to know where these came from. It's not a very precise statistic.
Is media part of that business category, or is that a separate category?
It could be. Media is a separate category. Media was 8,300 that year.
Okay. And for my own knowledge, how much for one of those 21,000 business inquiries, how much is a general ETHI request to a department? How much is the cost on a business to file that?
How much it costs the business, or how much it costs the government?
Well, how much? I'm sure you pay a fee when you're putting in an ETHI request. What is that fee?
The general fee is $5, and then there can be other fees that can be charged.
So, do you? I know the Access to Information Act is from the 90s, I believe. Do you know if that $5 fee has changed under your term or before it?
No, I think the $5 has remained a constant since 1983.
Interesting. Do other countries bifurcate their ETHI process where they charge, say, a nominal fee for public applicants and they charge a different higher fee for commercial entities?
It varies from country to country. I certainly have not studied in depth for that today. I know in the U.S. it varies. For instance, there are some groups that get their fees waived. And in Canada as well, there is a discretion to waive fees. In the UK, I believe there is a difference in fees. In Ontario, there are higher fees. It really varies from jurisdiction to jurisdiction. The recommendation in terms of international norms is to charge no fees.
Certainly.
But that really varies across the board from provinces and countries, very different models everywhere. I'm a strong advocate of no initial fees simply because, and we don't charge them in our office, I consider that it costs more to charge the fees than to actually get the revenues from the fees, and the fees that are sometimes assessed, they generate complaints as well. I find that it's not efficient in the system to charge the fees. The government is not recouping its money, and it delays access, it generates complaints. I just don't find it very efficient.
Do you know, so we know the $5 charge for the request has not changed since the 1980s. How much has the cost of processing the request changed since the 1980s? Do you have that number or an approximate?
There is also in the Treasury Board statistics an analysis of that. The average cost per request, they do have that from the period of 83 to 92. The average cost was $1,000. From 93 to 2002, around $980, and 2002 to 2012, $1,300. That came down last year. It's a little bit less, it seems. Those are the average costs per request.
The periods, you say there was a $1,000 threshold and then a small drop down and then a pop back up. Would the drop have been probably attributable to the computerization and the sort of standardization of the request process, and now the added cost is just the rising inflation costs of salaries and those sorts of things?
I really couldn't tell you, sir. I really have no basis for any kind of analytics on that.
That would have to wait until the next round, I'm afraid, to go any further. That would have to wait. 7 minutes is up. Thank you, Mr. O'Toole. Then we go to the Liberals, the Vice Chair of the committee, the new Vice Chair, Scott Sims.
Wonderful to be here.
You're up, Scotty.
Thanks, brother. We have Brother Chair. I wanted to just talk about the concept of what something I like to call is just open by default. You know, I guess when it comes to open by default, there comes a time when you have to update with technology to make it far more efficient. Just a quick question then. I remember calling in PCO for some information, and PCO reminding me, or telling me there's no machine readable. It was not possible to do, so for whatever reason, I couldn't, whatever. But if you open this up, you modernize it, it becomes far more adept to with technology we have today. Does that average cost, will that go down considerably?
Will the cost go down? I really couldn't tell you.
$1,300 is the
that's the average
standard.
cost for the last 10 years.
Right. And you're saying you can't really tell if that would go down, but what would be the cost of that? Like what comprises the majority of that cost in, say, the average price at $1,300?
I really don't know. The average cost is probably related to the people who do the redactions on the documents.
Ah. And if you had more powers to look at redactions, is that possible in the near future? That's something you would like to have?
I do have the the power under the Act to review all records except records that are excluded as cabinet confidences. So I do have the right to review all the records and to review all of the redactions except for cabinet confidences.
And there is a great deal of redaction that takes place outside of cabinet confidences? Is that correct?
There are a lot of redactions applied to access requests, yes. And if you look at tab 4, there is a graph in there at page 2 of that tab, which basically looks at this indicator, which I like to look at in terms of looking at how much information is disclosed per request. This is the proportion of all the requests where all the information is disclosed. And this is going back to 1999, looking at the statistics. So in 1999, in 40% of all of the requests, all of the information was disclosed. In 2012, 2013, we're at about 21, 22%. So when I look at the costs of processing a request, what I do see, certainly a correlation between the amount of time you have to spend making redactions and applying exemptions to a record, that's going to take you more time, and therefore it's going to be more costly to process a request. But this is based on the same piece of legislation. This is how we have evolved in administering the Access to Information Act over the years.
By way of information, I'm new here. When it comes to the redaction process, what do you do when you review it? What's the process for you personally when you review something that's been redacted and you say, you know, you have an issue with that?
We see the redacted copy, but we see the unredacted copy. Correct. So we see what's behind the redaction. So what you would get as an access requester, you would get a copy with portions blacked out, and you would see the number of the actual legal provision that's applied to that redaction. We get a clean copy, so to speak. We get a copy without redactions, and then we can determine whether we agree with that redaction or not based on the words that have been redacted.
Can you give me an idea how often that happens these days? What's the trend?
Well, we receive complaints. So we have essentially three large groups of complaints. We have complaints where people complain that their access request is not responded to in time. So that's what we call more of an administrative complaint. And then we get about half of the complaints that come in are about redactions. And of those, about half of those, we find that the redactions are not properly applied.
Okay, so you're
saying...
saying...
And then the third group is complaints about missing records.
And is there a graph to illustrate that you've handled more complaints about redactions over the years? Can you give me a trend on that?
Yeah, so I guess we could give you a trend in terms of the proportion of refusals versus administrative requests, but it's usually about 40% of administrative requests, and the rest is other types of complaints. Over year, since I've been here, it fluctuates a little bit. It's a bit high now in terms of administrative complaint. It's at 38%, but it's really fairly consistent.
Do you think parliamentary review is necessary for what it is you do?
A parliamentary review of all of the investigations?
Of your job, just in general, just for what you do.
Of what I do? Well, yes, I consider that it's very important to be overseen by Parliament and by this committee.
Have you asked for that in the past?
Well, we are here. There is a
Exactly.
standing committee that is reviewing the work of my office on a regular basis.
Told you I was new.
I'm just not quite sure what you mean. Maybe I don't understand.
Well, it seems to me like the act is stuck in the 1980s. That's my opinion. I mean, a lot of it, we talked about fees, we talked about other things. And I just think that parliamentary review is necessary to go through all of this.
Well, what I consider to be probably the most progressive access to information law in Canada is subject to a 5-year parliamentary review, and that's the law in British Columbia. And I think that is actually a very good process. There was an initial parliamentary review when the Act was passed in 1983, but there was only one in-depth parliamentary review done in the course of the last 30 years, and there is no specific provision in the Act for a mandatory parliamentary review of the Act.
You think every
You're
5 years?
Out of time,
is good?
Scott.
I think it would be an excellent idea.
Mr. Sims, thank you very much. Next, then, we go back to the Conservatives and back to Aaron O'Toole. You're like my leader in question periods, are you? You're taking all the spots.
But not as entertaining.
Oh,
Clearly.
surely. Well, the day's not over.
Thank you, Mr. Chair. No, and I'm going to continue along the line that I was on, Ms. Legault, because I do find it interesting to sort of review from my first round of the 55,000 requests of all departments, and I know that they're going up, and then what trickles up to you in terms of complaints goes up accordingly. 29,300 were commercial in origin or media/business. So that represents about 53% of overall requests. And if you look at the pure cost to government, I don't think anyone here disputes the need for this process, certainly, and we appreciate the work done by your office to close a lot of, increase your closure rate. But it was a $995 cost in 1983, $1,295 cost in 2012, representing $71 million cost to government. This is an important cost, but I think funding could be found for not just your office, but getting rid of this backlog, because I notice your graph at tab 3 has, you project this 30% rate to essentially continue out until 2018. So we're going to be essentially in hundreds of millions of dollars of costs, and we're still charging a $5 charge that was a 1983 price. Even the Bank of Canada's own inflation calculator says that should now be a $10.65 charge. Where I'm going is, would it not be smart for Canada to follow some other jurisdictions that have bifurcated this into a low-cost ETHI option for citizens, and a somewhat higher, not full cost recovery, not $1,295, but for a telecommunications company preparing for the CRTC, at a $5 rate, they can, and I've seen this, they can throw as many ETHI requests out as possible, whether or not some of them are even germane to their filing, because there's such an inconsequential cost for business, yet government absorbs all the work. Would you be in favor of a two-tier process where we keep price low, maybe the $10.65, and gear the citizen request to inflation, but have a significant higher fee for commercial requests?
Mm-hmm. You would find it very hard-pressed to hear me say that I am actually in favor of an increase in fees. I really don't think it is judicious. I really don't. I find fees generate delays for requesters. They generate extra costs for the government because they lead to complaints. I actually have a case in court now related to fees. I think these are almost red herrings, sir. I think it is definitely something that the government can study and look at the different models. We'd be more than happy to present information that we can find and gather in terms of various fee schedules and fee structures in other jurisdictions. It'd be our pleasure to submit that to the committee. I remain unconvinced that it is judicious to do that.
In a merger and acquisition where information and knowledge is valuable, I think you'd agree with me that there's a commercial value to some of this information to the corporate applicants. Correct? There is value.
Yes.
If we could address the volume and the volume of work that your report cited by charging enough, not to make it a barrier, but to make the purely commercial applicants think twice about just littering the landscape with requests, which is easy for them to do, but costs $1,200, $1,300 per small request. It would be not just a small supplement to allow an added budget for your office, but it would actually make the private sector whittle down to the information they truly need and allow the system to be faster and better for regular citizens.
Mm-hmm. Well, I would be more than happy to consider these matters. I think it is probably based on a premise that is perhaps not quite accurate, because the requesters, be it journalists or commercial requesters, they're actually requesting public sector information. They're not requesting information from a private entity. They're requesting government information, which is a public sector information. And at the same time, it's odd because we are putting forward open government and open government by default. The government signed the G8, and if you look at the G8 on the open data, the principle that the government has agreed to is to have free information through open data. And yet we're saying for access requests, we have to have a scaling fee schedule. I think we have to look at this in an integrated way. This is what I've recommended to the President of the Treasury Board, because on the one hand, we can't say we want open government by default, and open data that is free of charge and released quickly in a timely manner to anyone who requests it. But if you make an access request, we're going to charge you money on the scaling fee. We're going to have to assess you as a requester, even though under the principles of the Act, we're not supposed to question the reasons why you're asking information. We're not supposed to ask for the motive for which you're requesting information. We're not supposed to ask for your identity when you're requesting information. So going through a sliding scale of fees actually raises all of these other issues about the right of access.
Fair to say that Canadians would view an application or a request from a citizen and a corporate entity, could be a numbered company. Do you think Canadians would see those as different in the context of open and transparent government?
Have a very brief answer, please, Madame Legault.
I'm not sure. I can say you that as Information Commissioner, I really think we should think consistently in an integrated manner about open data, open government by default, which includes access to information. We should have one principle that applies across the board and make it simple. Simplicity actually generates efficiencies, in my view.
I think that concludes your time. Thank you, Mr. O'Toole. Then we'll go. That's the end of our first round of questioning at 7-minute rounds. We switch now to 5-minute rounds. And first up will be Matthew Ravignac for the NDP.
Thank you, Mr. Chair, and thank you, Madame Legault, for being here. I would tend to agree. I think Canadians would find it pretty bizarre that something that they're supporting with their their taxes and something which is theirs, which is public information, needs to be wrestled out of the government with high fees or fees that may be unreasonable. Not too long ago, the Conservative government did announce that they might consider or would consider making cabinet confidence subject to review of the Information Commissioner. Has that happened?
No.
And on the cabinet confidence redacting, are you even allowed to study the issue?
Yes, people can complain to our office. Cabinet confidences, the only thing that we see is a schedule. So a description of the records. We don't have the ability to review the records.
Is it possible to determine if that is those cabinet confidences redactions have increased in number in the last couple of years?
The number of complaints for cabinet confidences, I would have to get back to you on that. I can give you statistics on that. The government has changed its process in the summer of 2013 in terms of how it's processing the requests and the requests where they identify cabinet confidences. This is something that we're following very closely, but we don't have enough data yet to see any trends.
Well, I'd be definitely interested to know. I'd also be interested to know how much the $1,300 per request is actually due to cabinet confidence redaction in some of the costs. But I understand you probably can't answer that question right now. Another thing that they promised was that to ensure that all exceptions from the disclosure of government information are justified only on the basis of the harm or injury that would result from disclosure, not blanket exemption rules. Has that also happened?
No.
And in your opinion, would that be ideal?
In most instances, that test is certainly what's considered to be the best in terms of international norms. There are certain circumstances where that's not appropriate, but they're much more limited than what we have now.
So we are dealing with, right now, we are dealing with a system that has blanket exemption rules.
We're dealing with a system that is actually supposed to be based on open government by default. I mean, I looked at the Hansard for the 1982-1983 when our current legislation was put forward, and it was put forward on the basis of open government. Open government is a 30-year concept.
Now, you know that there are organizations out there judging our access to information system. We've been harshly judged. We're now 56th out of 95 countries, and we're behind Honduras, Belize, Colombia, Russia, Malta, Montenegro, Nigeria. That's very troubling. I think we have a proud history of democracy in this country. This is, I mean, deeply concerning. Can you tell me very shortly what is the main contributing factor in that failing grade?
In the failing grade, the evaluation by law and democracy, one of the areas where we're losing points is the scope of coverage. We don't have, we have a list of institutions that are covered as opposed to having a principled approach in terms of what institutions should be covered. For instance, Parliament is not covered, parliamentary administration is not covered. That is something that we see in newer pieces of legislation.
Thank you. There's another thing that really is troubling to me, and I think it's troubling to Canadians as well, and you actually reported on this, and that was political interference in the access to information system, particularly at PWGSC. I've read it. I certainly hope it's not a trend. I hope you have the power and the resources to track this kind of interference. Are you confident that with the law that exists right now that you actually can prevent this kind of interference in the future?
The public works investigations were extremely arduous. We were able to make very firm conclusions because they were documentary records. I think those investigations created a significant education across the system. I don't see complaints about political interference very often. We haven't seen or concluded in any other that had happened. When we have people that complain or have allegations that this is occurring, we have very extensive investigative powers. I think that the Act is well constructed in that respect.
Thank you, Madame Legault. Next, believe it or not, it's Aaron O'Toole again. On behalf of the PMO, welcome again, Aaron.
My time is done.
Oh, I see.
On behalf of his constituents.
Sure. A very very point I was about to make. Mr. Komanecki, welcome.
Thank you, Chair. Just follow up with some questions, if I might. You mentioned the 30% increase to large measure was with respect to heightened awareness. Does that apply for both categories, the public category and the commercial category, or are there differences?
This is my own perspective on this increase because it was the first time in about 10 years that there were more members of the public making requests. So it was a real change in the system. It was a real shift that we saw that year, and it was really significant. So we hadn't seen that before, and it was members of the public. So that was unusual.
I noticed that you've hosted an annual meeting of federal, provincial, and territorial access to information and privacy commissioners. Is that trend similar in the provinces as well, the 30% increase?
It's interesting you asked that because I actually did ask my colleagues this week for another purpose, and no, it wasn't a trend across the provinces. I think there was Alberta. Was it Alberta? Okay. There was one province that had an increase, but nothing along the lines of what we saw at the federal level. But no, I didn't see any similar pattern.
The $5 charge, how does that compare to the provincial charges for access to information?
If you really want to have a more detailed analysis of that, I think it would be best if we provided something to you in writing, because I'm not comfortable giving you a real big picture.
You don't know whether $5 is common across the country?
I think $5 is low compared to other jurisdictions, certainly compared to Ontario.
How does the $5 compare, say, internationally beyond the provinces of the country?
It's low internationally.
And so if it's low and you like simplicity and you don't like scaling, would it not make sense to increase it?
I think I've already said what I thought about increasing it. Other countries don't charge anything. There are other huge countries that don't charge anything, like India.
You would accept the fact that there is a difference between the public applying for access to information and a commercial enterprise or corporation, or somebody that has a vested interest that would gain something out of their response. Would you agree that there's a difference in type of request?
Well, no, actually I don't. As I said before, I really don't, because the Act is constructed such that the identity of the requester and the reasons for the requests are to remain personal and anonymous. And so once you start having a sliding scale, you have to get into the details of that. So that means your cost per request. If I receive a request...
I wasn't talking about a sliding scale, just keeping it simple by an increase, to bring it more in line with, as my colleague indicated, inflation and other factors, and notwithstanding the cost to actually produce the request. It would make some good sense.
It is, sir, obviously the prerogative of the government to decide to increase the fees to make an access request.
I noticed in your opening comments you mentioned that you were able to identify efficiency and some significant improvements in how you do your work. Can you indicate what that might be? And my follow-up question is whether in that conference you had over 2 days you picked up any best practices that might add to that.
Mm-hmm. What we've done over the years is we really streamlined our operations. Like, we do our administrative files separately than our more complex files, and I follow personally the very complex files. What we've done is we really do the administrative files in a very streamlined fashion. We have a group of people that just deal with those files. Before, they were all mixed up among all of the investigators, and then what we do now is we basically bring in people and we train them up. They deal with the more simple files, and they go to the more complex files. We have a better review process than was in place before in terms of the managers and the assistant commissioner. We've now recently put in place a mediation process where we're trying to actually resolve the files very, very quickly, informally. All of these things, the intake, the early resolution, the mediation, the more streamlined refusal process, these are all things that are occurring in other jurisdictions as well with my colleagues. So yes, we do exchange the variety of techniques for investigations, but you have to realize that at the federal level, our files are very, very different than at the provincial level. Like in my inventory, close to 20% are national security files. We don't see that at the provincial level. We have a different inventory of files.
Oh, thank you, Madame Legault. Thank you, Mr. Komanicki. Back to the NDP, Charmaine Borg. 5 minutes, please, Charmaine.
Oui, merci beaucoup.
Yes, thank you very much. We have this concept of open government, which you said it dates back to 30 years ago. And we also have a government that continues to make promises about open government. It's a good thing. But essentially, we need to make sure that we have everything implemented and truly act. In an ideal world, imagine that we have open government, everything is accessible by default. According to you, the number of complaints that you would receive, would they diminish? That's my analysis, but I'm wondering what you think. Yes, the theory is that if we have open government, if we have more proactive disclosure, there will be fewer access to information requests and fewer complaints. And that's why, under tab 5, I indicated what we have through open government and what we can have through an access to information request. You can see there are 200,000 data sets, geospatial data sets open. That's on page 1. That's geographical data. 200,000 elements of data are available. And then we have open data. And on the very last page, you have the types of things that people are asking for through access to information requests. And what you will see is that they're not the same things. Are we going to reduce certain types of access to information requests because things will be given openly? Likely, yes, because in the 1990s and 2000s there was a great deal of proactive disclosure about trips, about expenses. And what people did after that is they asked for the documents that supported what was openly published. Is that going to change what we see now? For 2 years, we've had the Open Government Initiative, and the result so far is that we've had an impressive increase in the number of requests and complaints. For the time being, the trend is not going towards fewer requests, but more. I'm looking at the chart, and to me, it raises a question. Perhaps we're not putting out the right data. We're not making the right data accessible. Perhaps we should look at what the complaints and the requests are among Canadian citizens and then determine what we need to actually put online. Not that I don't like geospatial data, that's great. But perhaps the balance is too heavy on one side. I think we need to look at what people are asking for through access to information requests. If people are asking for things that concern them personally, they may be asking for personal data. Some people are asking for information from security agencies. We had a great deal of complaints. People ask, half of the requests are made to citizenship and immigration. A great deal of them are made to the Border Services Agency because people want data on their border crossings in order to establish that they were a resident of Canada in order to obtain benefits. Those kinds of requests will never be information published proactively on a website. In my opinion, it's not the kind of information that the government is going to divulge proactively or disclose proactively. It would surprise me. Do I have time? 1 minute. Thank you. I'll change the subject. We talked about the Act, which is endangered and needs to be modernized. It's existed for 32 years. Please correct me if I'm putting words in your mouth, but you said that our system is likely to be broken, that it needs repair. Is there anything other than modernizing the Act that, according to you, would be essential to start fixing these problems, to start fixing the system which is so broken? I'm very optimistic, in fact. I really like the Open Government Initiative. I really like the new directive that the government has put forward, because the main line of the government's directive on open government is that the government is committing to establishing a government culture of openness by default. And I think it's the first time I've ever seen such a strong statement from a government that is committing to changing government culture. That's the essential pillar to have open government. And then the pieces that we assemble, we have the Access to Information Act, which must be a modern act. We have the implementation of that act, which also must have sufficient resources. We have the administration of open data. All of those become pillars in order to uphold that cultural change. I gave a speech this week that a cultural change is what we need, and the government has committed to it.
Next, then, we have for the Conservatives, Joan Crockett. Welcome to the committee, Joan.
Okay.
I guess you're next.
I guess I am. Thank you very much, and thank you very much to Suzanne Legault and Leila Michaud for being here with us today. I really appreciate your passion for information, and especially having come from the newspaper business, where we rely a lot on access to information to get our information. It has been something that I've been quite familiar with. And because I came from the newspaper business, I just want to draw a bit of an analogy, because the world has changed very dramatically for newspapers since, if we take 1983 as kind of a benchmark. We used to, in newspapers, consider that all the information was free and public, was in the public domain. And I don't know if you have a subscription to a newspaper now. I presume, do you? And I'm wondering if you now pay for articles that you want that are in past newspapers.
Personally, no, I don't.
Okay, so why do you not pay for them?
For newspaper articles?
Mm-hmm.
It hasn't occurred to me that I needed to do that, but I don't know.
Okay.
Maybe if I wanted an article, I would pay for it. I don't know. I just haven't personally done that.
So I just wanted to put the premise to you that a lot of people are going to the government now. I'm wondering if you might agree with this. A lot of people are going to the government for information that they might previously have received through their newspapers, but it's some information that might have been printed in the past.
I don't see all the 55,000 requests, so I really can't comment on that. But what I do see in the complaints files, it's not that type of information. It isn't.
So I think you testified that the number of access to information requests you've had has gone up 30%. So I just wanted to draw your attention. I have tab 4 here with regard to the requests that have been received by your office, and I see that some of the interesting ones here are that while your overall access requests have gone up 30%, the requests from Industry Canada, involving Industry Canada, which was, as you know, a business department, 50.6%. The requests from Finance, 65.5%. The requests from Natural Resources Canada, 114%. And I'm wondering if that might lead you to conclude that a lot of the requests that are coming in are requests from businesses, from for-profit enterprises that may be utilizing this information for profit.
I really don't know. I think that we would have to go back to the departments, because These statistics are all collected from the government. These are the government statistics. They're not my statistics. I look at them because I like to analyze the health of the system that way, and it gives me an understanding of what's going on. But beyond going behind all of these numbers, we would have to go back to the annual reports of these institutions. So if you want us to do that, we'd be more than happy to go back and look at those annual reports for those 4 or 5 departments, and I can send the information to the committee. We'd gladly do that.
Yeah, it seems to me that this, if you're in such dire financial straits as you have painted to us at the beginning, and I do sense your passion for freedom of information, I have to wonder why you haven't considered the fact that this Access to Information Department, when it was set up as an organization that was going to be in a partial cost recovery model, and that has been eroded over time, has it not?
I am not aware that the $5 was ever meant to be a cost recovery mechanism. I'm really not aware that that was ever the motivation for that.
What do you think the motivation for that was?
What I hear in the system is that that is to prevent having frivolous and vexatious requesters.
And so then would that not also make sense that we would still want to have that fee under that rationale so that you might be prevented from having frivolous requests coming to you?
I don't think that it's an appropriate mechanism to put some discipline in the legislation. The Federal Access Act is one of the few pieces of legislation that actually has no discipline, either on the number of requests that a requester can make at one time to a department, or whether there are considerations of frivolous and vexatious from the requesters. Most other pieces of legislation do have that. I don't think that the fee is an appropriate mechanism for that. It's my perspective on looking at how the system is working. And if we were to have a cost recovery mechanism put in place for access requests, what would be the fee? Would it be 10, 15, 20, 25, 100, 200, 300? Is there a fee for a complaint? How do you assess whether a corporation is it a large corporation? Is it a small and medium-sized corporation that's making a request? Is it an independent journalist that's making a request? Is it a journalist from a big media organization?
I'm afraid I'm going to have to interrupt both of you, that you're well over time, Madame Crockett. Thank you very much, and thank you, Madame Legault. Next, we'll go to the NDP, and I'm sorry, where are we? Mathieu Ravignan.
Yeah, on the open government plan, you've said, and I'll quote you just so that it's fair, I remain of the view that the current commitments in your plan will not achieve the stated objectives of the government to effect a fundamental change in government culture, one that will drive the release of federal information and foster transparency, accountability, and citizen engagement. Slight contradiction with your positive attitude when you were speaking to Madame Borges. With such a damning statement, what gives you any confidence that this is going to be successful?
Well, I am confident. I mean, I think there is a public statement on behalf of the government that this is their stated objective. My recommendations are that the way that the action plan is currently drafted, I just don't think it's going to be sufficient to actually achieve that objective. And the main reason is we want to have open government by default, but we're going to open government by default by proactively disclosing what's considered to be eligible information for proactive disclosure.
Maybe as we just I don't share your positive. I mean, there's a lot of comments that have come out, but when the government recently announced some of the open government stuff, there was more about what was missing than what was in it. I mean, the government rejected comments from your office. It rejected public consultations, experts, and even your own advisory panels, right, for the need to update the Access to Information Act. Michael Geist said that the consultation process was a farce, that basically decisions were made in advance of it. Do you agree with his assessment?
I agree with what I stated in my letter, that I think that the commitments are not sufficiently ambitious and they're missing the mark in terms of modernizing the Access to Information Act. You will not have a proper open government by default if your access to information exemptions and the scope of those exemptions is so broad that nothing is going to get disclosed. At this time, and I have said this as well, the Access Act actually works as a shield to the disclosure of information as opposed to a lever for disclosing information. And that's why that missing piece is crucial.
Yeah. And one way of going about making sure that it is actually about the release of information would be to oblige public officials to create records necessary to document their actions. Also provide a general public interest override for all exemptions. And are we headed in that direction?
Well, I am going to present a very broad set of recommendations for amending the Act in January, and those things that you mentioned are going to be in there, amongst other things, but not increase in fees.
Well, that's I commend you for the inclusion. I think that that's pretty fundamental. Now, the role of journalism in this country, particularly investigative journalism, but journalism with some strong information. It's not an exaggeration that the access to information is the fundamental tool that they use in order to keep us all accountable. I don't know how many times I've heard from journalists frustrated with the length of delays, with the timeliness of the information. And the timeliness of information is essential to the functioning of our democracy because a hot button topic can suddenly disappear from the news cycle. And if you don't get that information in timely fashion, it doesn't work. So there's a direct relationship with just the fundamental health of our democracy. How have journalists approached your office, and what is your sense of where they're at on these issues?
If you don't mind, Madam.
Sure. Okay, 30 seconds. Okay, journalists are very frustrated. The Act lacks discipline in terms of timeliness. I am in Federal Court of Appeal with a 1,110-day extension, which the first level at the Federal Court judged that I could not determine whether that was reasonable or not. And this is compounded by the fact that at this time, given the resource level, there is a 7-month delay in my office before I can investigate a case. Once I do assign it, the median turnaround time is 90 days or less. So it's not because we're not efficient. It's because we don't have the people to do the investigations.
Thank you, Mr. Ravnia. Thank you, Madame Legault. Then we'll go back to the Conservatives, and this time, LeVar Payne. I'm sorry I missed you last time around, Mr. Payne.
No problem, Mr. Chair, and thank you for the opportunity. Thank you for attending here today. We were looking at your website and looked at your early intake resolution unit, and certainly you've talked a bit about your backlog today. So I'm wondering if you could tell us when was that early intake unit started, and how did you start addressing that backlog? How long or how old was the backlog, and how is this early intake unit working now?
The early intake unit works really well. If you go to the tab 3, where you look at the progression of the inventory, when I first became interim information commissioner, I walked into an office that had 2,500 cases in its inventory. And every year we've managed to come down with that inventory. We had a decrease in the inventory. That means we closed more than we received every year, except for the past year where we had the 30% jump. So as far as I'm concerned, like, we have gained efficiencies all the time, and we were making really, really good progress in terms of diminishing the inventory, and the intake is a really good success. We've just added now a mediation component to it, and that is generating some good results as well. What we're trying to do there is really trying to see with the complainant in the institution right away when the complaint comes in whether they're really getting what they're really looking for, and whether they can circumscribe their request or their complaint, and whether we can resolve the matter more quickly with the institution, and that's working really well too. So the intake works very well, but at this point, in terms of efficiencies, we just did a whole mapping exercise. We're constantly looking to make things better, but the efficiencies now I can gain are marginal. I'm not going to close 2,000 complaints more. I may close 100 more, I may close 30 more, but I'm not going to be able to close the 2,200 that I've accumulated again.
Okay, so obviously you've made some progress there, and I guess one of the other things is when you're getting these complaints, could you explain how they're first of all brought to your office, and how you determine whether they're fair, and is there a specific criteria in place for those requests in order to make sure that they are fair?
I don't determine whether they are fair. I determine whether they fall within the jurisdiction of the law, because there is a positive legal obligation. One of the things that I am going to recommend in the Act is that there is discretion in the Commissioner in terms of investigating or not. At this time, there is no discretion whatsoever. If it falls within the mandate, and the mandate is described very, very broadly, any matter having to do with requesting records or obtaining records from a government institution. So the jurisdiction is spelled out very, very broadly, and once it fits into that, I have to investigate it.
Okay, so if you have some cases that are not deemed needed for investigation, what happens to those cases?
We just advise the complainants.
Okay.
We don't open those files. Okay. We just deal with those on the phone. We don't actually even, we should, but we consider those inquiries.
Okay. Do you have any idea the number of those cases that were determined to be inquiries?
Just the inquiries? Are we tracking those now? No, we don't track those.
Oh, you don't track them?
No.
Okay.
We have one person that takes those inquiries in.
Okay. I was also looking in terms of the $5 fee. I understand that you need a Visa card or a MasterCard or something like that in order to start the application process. But I also noted that in order to be able to instigate one of these, you need to be a Canadian citizen, permanent residence, corporation. So how do you determine that, or because you talk about privacy and so on?
That's done at the departmental level because the access requests go into the departments. When people complain to us, they've already made a request, the department's already established that they fit into that. And we get the complaint, we then get the file number from the institution, and we work on that basis. We work with file numbers with the institutions.
I'm afraid, Mr. Payne, that concludes your 5 minutes. It goes quickly. Oh, I know. I'm sure you had lots more. We're going back then to Mr. Liberal Party, Mr. Ted Sue. Welcome, Mr. Sue.
Thank you. Thank you, Mr. Martin. Thank you, Mr. Chair. My first question is about the delays, Madame Legault, in your office because of the lack of officers with top secret security clearance. And I believe that you only have one officer with that designation now. My first question is that correct? And then the second question is, do you feel that having more officers with that top secret clearance would be an effective way to reduce delays in responding to complaints?
The answer to that is yes. However, I did request, we call those investigators that are allowed to see certain files under certain provisions of the Act dealing with international affairs and national security. They have to have a special delegation. And I sent a letter to the Treasury Board President last year asking him to increase the number of people in my office that were allowed to do these investigations, because he has the authority to do that under the Act, and he did, and that was increased from 8 to 12. I would rather have 20 to do that, but I don't even have people even to put in that slot because I can't put everybody to do these types of investigations. Top secret files at this time, I have less than 10.
Okay.
And I have top secret, the assistant commissioner has that, and I have at least one investigator that has that. So we're managing those files.
Okay, thank you. Do you believe that your office should have the power to compel the release of records and also to establish a timeline for the release of records? Do you think that authority would enable you to do your job more thoroughly? And do you think your office can fulfill your mandate without that power?
I think that generally speaking, there is a real lack of discipline in the Access to Information Act in terms of timelines, and that also flows into the power of the Commissioner to order the release of records. I do believe that the Commissioner should have the power to order the release of records, and we should have an order-making power model like we have in other jurisdictions in Canada. I think it works really well, and what it does, it really focuses the minds of institutions when they make representations as to whether or not information should be disclosed, and so it's faster. The Ombudsman's model works, but it takes a lot more time.
Thank you. With respect to the Access to Information Act, do you think that the purpose section of the Act should be modified so that it includes having government information being openly available to the public and accessible in machine-readable format, and that exceptions should be rare? Is that would you agree with that proposal to ensure that the government's information is open by default?
In my opinion, that's the way the Act is constructed as it is. I see what you're saying in terms of amending the purpose clause. Most people who want to amend the Act want to amend the purpose clause. Personally, I'm a lawyer. The purpose clause has been interpreted quite well by the courts in the last 30 years. I am somewhat leery of amending a purpose clause for that act. I would like to see the specific language. You may be referring to C613. And if that's the case, then I think it would be more appropriate perhaps to comment specifically on a piece of legislation if that's what you're referring to.
Okay. I understand also that the Access to Information Act maybe has not been updated in significantly in many years, and I'm wondering if what you would think about the idea of a parliamentary review of the Access to Information Act every 5 years, given that technology changes and how government operates changes. Would you agree with that recommendation?
I am definitely in favor, so long as it starts this year and not 5 years from now, and then continues after that.
Well, I think I would. That sounds like a good idea.
Seconds, Mr. Sue. So briefly, please.
Oh my goodness. I once submitted an Access to Information request, finding out what instructions the minister gave to a department, so that because I believe as a member of Parliament, I cannot criticize civil servants. I can only criticize the minister. Do you think that instructions by ministers to departments should be more public so that we know the chain of accountability?
Very briefly, please, Madame Legault.
We would have to see which record it would be and what exemptions had to be applied to those instructions. In principle, should they be disclosable? Should they be subject to the Act? Yes. Should they be subject to exemptions for personal information or solicitor-client privilege or other things like that? Yes, as well.
We'll have to leave it at that then. Thank you very much, Mr. Sue. Next, we'll go to the Conservatives. Mr. Bowen, 5 minutes, please, Mr. Bowen.
Thank you, Chair, and thanks for the resource people spending the afternoon with us. We certainly are learning different things in your operation. When I looked at the highlights of your financials part, which is on page 2 of your handout, the differential there is $3.3 million. You talked early in the afternoon about having to do with less. Can you share with us how we ended up with a 3.3 million less funds? This is on this handout here.
Which one is that?
Prepared for the House of Commons Standing Committee on Access to Information, Privacy and Ethics.
I'm not sure that's my document.
Your name's on the front of it here.
Let me see.
If I can just say that, yeah, Madame Legault doesn't have the briefing note that was provided to committee members, but it looks like she's getting it now, Mr. Bowen.
I'm sorry, Chair.
Document prepared by the Library of Parliament. So I have that document now.
Okay.
So
yeah, I'm just kind of curious how that all came about.
The difference between last year and this year, sir, is because we had a $2.6 million loan to move our offices. We were lent the money to move our offices. We were booted out of our location, and we had to move. And so we were loaned $2.6 million to move. It cost us $2.6 million, and we have to repay it. And that's costing us an extra percentage of reduction in our budget because we have to repay it.
So the 2.6 ended up 3.3 due to interest on the outstanding loan. Yes? No?
Okay, there's 2.6 for the move, but as well, like we're at the end of a 5-year IMIT strategy, so there's almost 300K there as well. As well, we began last year to repay for our move, so there's 170K there. So we're close to the 3.3, and then there's some pay list shortfall or salary type of resources that were transferred to us, but we have to pay for other and so on. So it's mainly what it is.
Okay. Yeah. I was interested in your discussion about how you refer back to a client without an address, without a name. Does the client get a number, and the number matches the number with you folks? Can you help us understand how that transition happens? So.
Yeah, we try to protect the identity of the complainant as much as possible. Obviously, we have to function. We have to send them letters. But within our correspondence with the institution, within our institution, we mostly function by file numbers. So the institution has a file number, and we have as well, so that in the end, when we do write, for instance, if we can't resolve a file, we have to write to the minister, and I'm writing to the minister. All through these steps, we're only referring to a file number, so that people in the institution that are being asked to review their representations, they don't know the identity of the complainant. So that's how it works, and it's all in our data management system for our files. But of course, yes, we do have the name of the complainant eventually, and we do write to them, and some of them want us to write to them by email now and so on. So we abide by that, but we try to put these measures in place to protect the identity.
Okay. Thanks, Chair.
Okay, that concludes your time then, Mr. Bowen. You have about 45 seconds left if one of your colleagues wanted to use it up.
Well, I think the two women answered the questions I had, so.
Very good, very good. Thank you very much. We'll move then. It's to another round that's also with the Conservatives, Mr. Aaron O'Toole.
Thank you, Mr. Chair. Thank you very much. It's been a very interesting process for me, particularly, as I said at the beginning, because I did see when I was working in Toronto in law, the commercial value for information, and I have a few questions following something you said to my colleague, Ms. Crockett. You suggested, to the best of your knowledge, because you weren't commissioner in 1983, that the $5 fee was not really a cost recovery. It was more of a nuisance barrier, or to make it so that anybody applying has to actually think about. Is that an approach other countries use, like a sort of bare bones barrier, so that it's just there's not, like we see people on Twitter tweeting all day if something is just one click of a mouse button, and I think there has to be some sort of reasonable ground between open and accessible government and having at the flick of a mouse click bureaucrats being charged with gaining information and the costs of almost $1,300 inherent in each request. Where would you say that nuisance amount should be?
Well, let me ask you this question, because I'm not quite sure how to answer your question, as you have gathered by now. What's the nuisance cost of publishing a data set? What's the nuisance cost for the government to produce a data set and to publish it proactively under the open data system? There is a cost to the government to do that. There is a cost to proactively disclose travel and hospitality records. There is a cost to disclosing anything on a government website. So why is that different than releasing records to access to information? You see, in a way, you could look at it as a cost-saving measure, because the government is actually not disclosing everything that it produces. It produces some things proactively because it considers it has value, because it's open data sets or geospatial data. It produces other information publicly, like annual reports and departmental reports, because it considers that it's value for transparency and accountability. And so what's different to say, well, if citizens actually, some citizens, actually 55,000 citizens out of our entire population, it's actually a low number, want to have access to other pieces of information. Why is there a nuisance threshold for that information when the Supreme Court of Canada has determined it's a quasi-constitutional right of Canadians? That's the real question, sir.
I have to correct you, Madame. There's not 55,000 citizens. There's 55,000 requests, and we've established that almost 30,000 are not citizens. They're corporate entities. It's good to see my NDP friends here supporting corporate Canada and their access to records.
Yeah.
What I'm saying is, what my vision would be that I think would fill your coffers to address what is clearly a rising need, and your office's very good handling of it, is a system that is broken into three parts. One would be a zero charge for any access by a citizen to any document pertaining to them or their life. A second, more nominal charge of $25 or $30 for a citizen request for items not pertaining to their direct life, but if they're interested in fisheries and they want to see that, they should have that access. And it would be still a nominal charge, but it would be certainly a lot more than the $5 1983 amount. The third threshold would be for commercial entities that are clearly potentially commercializing the information. And a $5 nuisance threshold to billion-dollar companies, I would say, is not a nuisance threshold. It's not even tokenism. So if you had a $200 charge for a telecommunications giant or an oil company, I think that's reasonable for a corporate entity. The reason why I'm pursuing this line of questioning, I think it would result in what you'd like to see, more money, particularly if you were able to earmark some of that to your department, which I think we all agree is doing a good job. What do you think of my three levels? I know you don't support it, but do any other countries use that sort of... I know the UK actually assessed how much time it will take to gather the information, then charge on a fee threshold, and then charge a communication fee for the phone calls and stuff. Do other countries do it this way?
I'm afraid that Mr. O'Toole didn't leave you much time to answer that, Nicole. We're after 5 minutes already, but given the depth of the question, I'll give you a minute or so to answer.
Well, I think the best thing I can do is to provide the committee with some research, and then that can be the basis for your consideration, and whether I agree with it or not. But at least it'll be more factual for the committee to consider, and I think that's the best thing to do, to actually do a bit of a benchmarking exercise and look at what's out there. You will find that there's a variety of models. Again, I think that we're making the system more complex that way.
And I think your office should be given the time to provide a proper international overview. I'm not on this committee normally, so could I be copied on the...
Certainly.
Thank you very much.
Thank you, Mr. O'Toole. Then we're going back. That concludes a second round of questioning, but there is an appetite still, if you're willing to stay, Madame Legault. There's still interest on the part of committee members. So we'll begin a third round, and that begins with the NDP, Charmaine Borg.
Oui, merci.
Yes, thank you. I'd like to come back to the budgetary issue. In your statement at the beginning, you mentioned that if your financial situation is not reestablished or improved in an accelerated or urgent fashion, that you will have to cut into programs. Could you specify whether you've looked at which programs could be cut, which ones are at risk, which ones could be cut if the financial situation is not addressed quickly? I have a program. I lead investigations. That's what I do. And that's the situation I'm in. If we don't have additional funding, I cannot live with the $37,000 of room to maneuver. If a server breaks, I will have to close the shop, so to speak. That's not a solution. I'm at the point where I need a contingency fund where I put $400,000 to $500,000, which is 7 or 8 positions among the investigators. That's where I'm at. I don't want to have to cut staff because I have many people who are leaving on maternity leave and some people who are retiring. I am simply not going to replace those individuals with the impact that we're seeing in the table. In my opinion, this would be a disaster. I am no longer able to ask more of my staff. It's been years that I've done so. They're working to the maximum of their capabilities, and we're going to continue to work in this way. But there's going to be longer and longer delays. When a waiting period becomes so long that we simply have no valid process of inquiry, I'm no longer able to fulfill my mandate, in my opinion. Thank you very much. My colleague, Mr. Ravignan, asked about